Welcome to Aspen Leading Edge. I'm Patty Roberts from St. Mary's University School of Law. Today's guests include Joseph William Singer, who is the Bussey Professor of Law from Harvard Law School, and Eduardo Peñalver, who is the President of Seattle University, soon to be the 49th President of Georgetown University this summer, 2026. And we'll be talking today about Property Law Rules, Policies, and Practices, the 9th edition through Aspen, that includes as co-authors Nestor Davidson, a Harvard University affiliated professor, and Bethany Berger, Associate Dean for Academic Affairs and Vestal Chair in Law Professor at Iowa College of Law. So President Peñalver and Professor Singer, welcome to Aspen Leading Edge.
Thank you.
Thanks.
So I'd love to start by talking about how this book first arose. Who started the case book, Property Law Rules, Policies, and Practices, back when it just was a first edition? And how did the evolution happen where we ended up with 4 extraordinary experts in property on the 9th edition?
Well, I wrote the first edition of the book by myself, published in 1992 or 1993, I forget the exact date, and then went through several editions. I think it was like 3 or 4 editions before inviting Bethany, Nestor, and Eduardo to join. I wrote the book because at that time in the early 1990s, Westlaw and Lexis had become available to law professors for free, and personal computers were just starting. And I was able to sit at my desk and actually do research on the property law of every single state. And I could search for state Supreme Court cases. And I started doing that. And I was astounded by what I found. What was surprising to me was I found disagreement about almost every single basic rule of property law. There were different rules, there were different nuances, there were different exceptions. And I also learned about a lot of statutes that were not in the case books at the time. So I was very interested in having an accurate, up-to-date statement of what the law was. But I also was very interested in including in teaching materials both minority rules and any kind of disagreements about how to understand the law. And that was because it was my view that even if one state has adopted a different rule, I assume that the judges or the legislature in that state have good reasons for that. And that automatically places all the rules, the traditional rule, in some doubt, because it means that there are arguments on both sides. And then that seemed to me a really good teaching device to actually explain the differences in the law and to be very clear about that, and also to then have students debate what they thought the law should be. I also thought that at that time, a lot of the case books did not explain the rules very well. And a lot of the rules in property are quite technical, come from hundreds of years ago, some of them. And just reading a case about a complicated rule of law usually wasn't enough to make it clear to the students what the general sense of what the legal rule was. And I didn't think it was right to make students read an external book to figure out what the rules are. So it was one of my goals to make the law very clear to them, and then prompt discussion in class and in their thinking about what are the justifications for the rule, why might a different rule be chosen by some states, and what kinds of arguments would be made on which rule would be the better one. And so the new technology, the personal computer, and the ability to use Westlaw and Lexis made it possible for me to write a case book much more quickly than would have happened in just the generation before me.
That's so interesting, and I find it especially informative as we are on the cusp of so much increased utilization of AI, and I wonder how much easier AI will make writing textbooks, casebooks in the future. So we're at another moment like that. So you wrote this book. I'm sure the students, certainly back then at the first edition, were not used to books that had the opportunity to debate positions. I imagine they enjoyed that very much. And has that approach to the book continued?
Yeah, so we have a lot of lawyering exercises in the book, and the 9th edition labels them that way, that they're exercises that are things that a lawyer would actually do. Some of them are giving advice to a client. You've just read the law. here's a client that has this problem or this goal. What advice would you give them given the law that you now know about? Other problems focus on should we distinguish the case if this new fact is put into the picture, or, the majority rule is this, the minority rule is that. If there were an oral argument or briefs on both sides of the question, what arguments would you make on both sides? And then sometimes we, have direct questions to students about what law do you think is better? But most of our learning exercises are trying to get students to understand why there's disagreement about the rule, what the goal of the rule is, and asking people to think both about rights and arguments about fairness and expectations, but also to think about how to make the property system work well, how to encourage desirable investment in real estate, and also how to discourage undesirable development, how to make the property system fit the general welfare, but also be consistent with the values of a democratic society that believes in liberty and equality and government of the people, by the people, and for the people.
Terrific. And Eduardo, when did you join and what prompted you to join, and what role have you played since becoming a co-author?
So we joined, I can't remember which edition. Was it the 5th or the 6th?
I'm not sure. One of those.
It was over 10 years ago. I had always been a fan of the book. When I became a law professor at Fordham, my dean there, Bill Traynor, recommended the book to me, and I had a number of people suggesting case books. When you're a new professor, everyone has a advice to offer on that front. So I looked at many property case books and really gravitated towards Joe's book, the approach, found that I could teach with the book rather than against the book, which was really helpful for me. I think Joe, the book that he wrote, it does a really nice job of exposing students to a wide range of approaches, but it has a perspective, and I find it very humanistic in its approach to property, which kind of matched my own thinking on property. So when he invited Nestor and Bethany and me at the same time to join the book, and we all jumped at the opportunity to become part of just such an amazing project. And I think we've tried to really stay true to the priorities that Joe had when he started the casebook, and we just kind of as we've gone about adding topics and updating topics, we've brought I think our own perspectives and fresh eyes to the material, but I think it's very much stayed true to Joe's vision.
And was one of the reasons because of the discussion of the social ramifications of our system of property law and the treatment of individuals with fair housing and public accommodations? I know you bring with you a philosophy and theology background. So is that something that is more heavily covered in the book than in other property case books?
Topically, there are a number of choices that Joe made that are different from many other casebooks. I mean, one is the inclusion of statutes and, the understanding that property is not purely common law, that it's impacted by statutes, and some elements of the common law have been codified in statute or modified by statute. So that's one big decision to include a set of materials that makes it different. But the other is as you say, the breadth of the topics, and I think Joe's appreciation of topics like fair housing and civil rights statutes as part of the body of property law, which I think is absolutely right as a conceptual matter. Greg Alexander and I wrote a book on a sort of introduction to property theory, and in the first chapter that we spent some time on what property is, like the definition of property, and we ultimately settled on a definition that focuses on property as sort of allocation of decision-making authority over resources, scarce resources. And if you think of property that way, then civil rights statutes go right to the heart of that. Who they're saying something about who can control access to certain kinds of property and the limits of that control. And so those are property decisions, but they're not typically included, or in any depth anyway, in most property case books. So it matches my own kind of academic thinking on the subject, but I think it also has a set of normative commitments behind it. My work on property theory is not theological, but it's definitely, I feel like it's informed by reading I've done in philosophy and theology. And Joe and I, when I was in Chicago, we had a really nice conversation that was sponsored, I think, by the Lumen Christi Institute, talking about Jewish and Catholic perspectives on property. And as we had that conversation, I was struck by how similar they are in their thinking about property as, both protective of individuals and as also a sort of social institution, and the limits on property that implies. And there's just a common kind of core, which makes a lot of sense if you think about it, between Jewish and Catholic thinking on property. And I see those traces of that in, some of that's very explicit in some of Joe's books, like the edges of the field, but it sort of suffuses Joe's thinking about property.
That's so interesting to compare the two religions' approach to property.
And I wanted to say something about that as well. As Eduardo said, one of the reasons for including public accommodation statutes and the Fair Housing Act was to make sure that there were statutes in the book. The books that were prevalent before 1990, if they had any cases interpreting statutes, they would just have the case. And ordinarily, they would be interpreting 2 or 3 words in the statute, and they wouldn't actually give students the opportunity to read statutes and analyze them and apply them directly rather than just through a case. So I thought, having public accommodation laws and having 4 or 5 pages of the Fair Housing Act, and then as time went on, some pages of the Americans with Disabilities Act, it would give students an opportunity to reason directly from interpreting the words and policies of statutes rather than just looking at what a case said about them. I had the experience of working for a law firm for a short time before I became a professor, and there was a summer associate who wrote a memo about some topic, and the partner in charge asked her, did she find any statutes on the question? And she said, statutes? And he said, yes, statutes. And did you look for statutes? And she said, no. And he said, why not? And she said, you asked me to research the law. And so I thought it's a mistake to leave statutes for the second year of law school. There's now a real effort by law schools to have more statutes in the first year, but I think statutes should be incorporated into the contracts, torts, and property classes also. The other thing is biographical, that it actually makes a difference what generation you're in, what experiences you have. I was born in 1954. 1 week after the decision of Brown versus Board of Education. The Fair Housing Act was passed when I was a freshman in high school. The 1964 Public Accommodation Law was passed when I was 10 years old. So, this is not ancient Greece. I actually remember racial segregation. And so when I started teaching, I noticed that public accommodation statutes were not in the property books. And I asked my colleagues, why not? Because they are a limit on the right to exclude, and the right to exclude is part of trespass law. And it seemed to be a pretty important limit on the right to exclude. You cannot exclude someone from a motel on the basis of their race. And the answer I was given was, that's not property law, that's civil rights law. And that just seemed unresponsive to me. If you just think conceptually about when you're allowed to exclude people and when not, it seemed relevant. And also important because I lived through it, and it was a social revolution in the United States, not a minor event. And then also, as I thought about it, it actually had very important lessons for thinking about property in general. Because in your home, in your apartment, you're allowed to decide who comes to visit you on any basis you want. You're allowed to choose your friends on the basis of race or religion or sex or whatever. Because in the home, interests in equality are subordinate to interests in privacy and freedom of association. But in a restaurant, the interests in privacy and freedom of association give way to interests in equal access to the property system. That's true for the Fair Housing Act also, and Title VII, employment discrimination. And so that actually taught a very important lesson about property, that the rules about property are not the same for places that are private versus places that are open to the public. So I thought this not only was an occasion for learning statutory interpretation and just conceptually part of trespass law, but also a hugely important lesson about how to understand what the rules are about property and why they differ in different social contexts. And that just was an insight that I thought was missing from some of the other books at the time.
Now, I notice in the description of the book that you also cover tribal property issues and intellectual property. Are those topics typically covered in a first-year property book, or is this another differentiator?
Well, some books have some material about intellectual property. We have a somewhat larger section on that than I think Most of the case books do. Some first-year property teachers are very interested in intellectual property, and some students also are quite interested in it. And the rules about intellectual property are quite different from the rules about real property. Part of the issue in writing a case book about property is that there are more rules in property than I think any other of the first year subjects. So you have to make choices about what to include and what not to include. And it's possible to sort of leave topics out to make the book shorter. But our notion is that first year teachers should be able to shape the class in a way that ties in with their interests, because if the teacher's interested in a subject, they're likely to be, a more effective teacher. And so we wanted to have teachers that know intellectual property or are interested in it to be able to incorporate it into their courses. The tribal property stuff came in because I became an expert in federal Indian law after I wrote the first edition of the book. There was a Supreme Court case called the Brendale decision in 1989, which was a conflict of laws case about zoning. So that's quite odd. If I live in Cambridge, Massachusetts, if I bought property in Somerville, the next town over, the property in Somerville would be governed by Somerville zoning law, not Cambridge zoning law. But there was a conflict between tribal law and the law of the county on the Yakima Reservation. And there was a Supreme Court case about this. I thought it was really fascinating. And I read the case and I thought, well, this puts two of my courses together. I teach conflict of laws as well as property. And it got me very interested in the field. And I learned that the rules about tribal property were quite different from the rules about the fee simple. And the more I learned about it, the more I was interested in it. And then I realized that the typical way of teaching Johnson versus McIntosh is not necessarily a correct understanding of the actual holding of the case. A lot of people teach Johnson as if it meant that the tribes had no property rights because the U.S. has the ultimate title. But if you read the entire opinion, which I did and studied it, the opinion refers to Indian title 7 times. So the title is actually split between the United States and tribes. And then as I learned more about the law in that field, tribal property rights are quite robust. And the way people were teaching it wasn't really accurate. And I wanted, to have an accurate understanding of that. But then I also had an understanding that tribes exist today. The tribes have governments and they have laws and they have businesses, they have courts, they have police. They're part of the federal system. And I thought it was unfortunate to teach tribal property as if it was something that vanished in the past. I wanted to have some material that allowed people to understand current issues about tribal property rights. So that part of the book was partly to correct what I thought were misunderstandings about the nature of tribal title, but also to make sure that people have a basic understanding of the actual origins of titles to property in the U.S., which come from transfers from tribes to the U.S., mostly through treaties, sometimes through statutes, and also to make sure people are aware of tribal sovereignty and that there are native peoples today that control 2% of the land in the United States. And it just was important to me to have that be an accurate understanding of the place of tribes in the current federal system.
Well, I know from talking with you both that Property Law Rules, Policies, and Practices 9th edition is very comprehensive coverage of property topics, as we've been discussing. But you're also offering students and professors the opportunity to get ready for the next gen bar exam on the horizon. So how has the book been modified so that students have that opportunity?
I think what I would just say about that is that we make sure that the book is up to date and accurate. For each section of the book, we do research to figure out what's happening with the law, rather than just assuming that the law that was in place 10 years ago is still the case. The rule against perpetuities, for example, is sometimes presented in casebooks by starting with the traditional approach and then having a few notes about the uniform statutory rule against perpetuities. But the uniform statutory rule against perpetuities is the majority rule now. More than half the states have it, but also a fair number of states have abolished the rule against perpetuities. So giving people an accurate picture of what the law is both prepares students for practice and to be able to actually understand accurately what the law is. The other thing is our exercises that we have that can be done in class are meant to prepare students to give advice to clients, as well as to be able to read statutes, to be able to give advice about ambiguities in statutes, and to be able to help students think about the practice of law, which is not just giving a law review article about the complexities of an area of law, but helping clients achieve their goals within the bounds of the law.
Well, I think that problem method and those exercises are really going to be helpful for teaching students legal reasoning and lawyering skills, and also preparing them for this new behemoth of a bar exam that's coming. When will Massachusetts adopt? I don't think I remember.
I don't know the answer to that.
Yeah, me neither. Texas kicked it down the road to 2028, so we have some time. All right. Well, I know that the 9th edition also includes some additional Supreme Court cases, some significant cases in property law. I wonder if you want to highlight one or two topics that the court has either made significant changes or that you're looking towards in the coming term for them to decide.
Well, one of the major cases I decided was the Grants Pass case, which overruled the Martin case, which was in the 8th edition. So the 9th edition has the Grants Pass case that says it's not a violation of the 8th Amendment to arrest homeless people for sleeping in public. We have that case there with notes about it, and it, can frame a class discussion. There may be other constitutional provisions that might be relevant, like the Due Process Clause, but also local municipalities have to determine what the right policy to adopt is in terms of their homeless populations, including camps that happen. Arresting homeless people is not the best solution to the problem. Telling people to move along just has people go violating the law someplace else. But that's a significant change in the law that we put in the book, and it gives an example of how we want the book to be current, about current issues, and up to date. The other major case that I can flag for right now is Tyler versus Hennepin County, which was a takings case that said when a municipality takes property in a tax foreclosure because someone didn't pay their property taxes, what the government is supposed to do is to sell the property and use the proceeds to pay off the unpaid taxes and give the rest of the money back to the homeowner. But some states were not doing that. Some other state laws said that they could take the property and sell it and use the proceeds to pay off the tax debt, but then the county could keep the rest of the money. And the Supreme Court said that those laws were a taking of property without just compensation. So the Supreme Court has taken cert in a follow-up case, Ping versus Isabella County. And the question is how to determine how much money should go to the homeowner when there's a tax foreclosure. And the issue is quite a complicated one. But when there's a tax foreclosure, very often, the property may be taken by the government for far less than its fair market value. And so is it that initial price that determines what goes to the homeowner, or do we look at the fair market value of the property? And probably fair market value of the property is much fairer to the homeowner, because the homeowner should get the equity they've built up in the home. The municipality should get the taxes they're owed. And what's interesting about that is if the Supreme Court says that, that's going to make tax foreclosures much more complicated. It's going to require different procedures. And on top of that, what's interesting to me, that may place in doubt mortgage foreclosures, because mortgage foreclosures in the United States are generally done by auction. And very often mortgage foreclosures are done for far less than the fair market value of the property. And a lot of property scholars have argued for years that that's unfair to homeowners. And this case may have reverberations for mortgage foreclosures more generally. And that would be an enormous change in the law if it were to happen.
One other Supreme Court case that we included in this edition is the Andy Warhol Foundation for the Visual Arts against Goldsmith, which is it's an IP case from 2023 that looks at what the meaning of fair use is, and whether a use that's transformative is by definition fair use, or whether you kind of stick with the traditional test and the transformative nature of the use is relevant but not decisive. And the court held that that it was not decisive, that in this case, the commercial nature of the use matched the purpose of the original work, and sort of reversed it affirmed a Second Circuit decision that had reversed a summary judgment in favor of the fair use defense. So it narrowed, I think, somewhat the fair use defense, but just made it a little more factually contingent, less categorical. And really an important case on the meaning of fair use, and moves the law in that area. And came in for a lot of public commentary. So we had another fair use case in the book and substituted it for this one. Nice to have a Supreme Court case. I think the case we had before was a Court of Appeals case. So an important case. And again, for the people who teach IP in the first year, I think one that they'll enjoy teaching their students.
Well, terrific. Congratulations again on the 9th edition of Property Law Rules, Policies, and Practices with co-authors Bethany Berger and Nestor Davidson. Before we conclude, I would love for you to share with me what your predictions are for the future of legal education in the coming decade. And while you are a president now, you were once the Cornell Law School dean. So maybe you can start and share, where do you think legal education is going in the coming decade?
Yeah, of the people on this call, I'm the farthest from legal education. So good that I don't get the last word on that. As I think about it from the perspective, certainly of the university and where legal education fits into the university, I think it will become more integrated, more central to the work of universities. When I was a law school dean, I came in at Cornell, and we had the reputation at the law school of being kind of separate. And law deans always joke about this. I remember when I was at a meeting of law deans, someone mentioned another dean who used to walk around with pencils that had on them printed the phrase, "The law school is different," that they would hand to every university administrator.
Oh my gosh, I love that.
And certainly as a president, I hear that a lot from my dean. But it's different for sure, but different in good ways and different in ways that I think are really relevant to the work of the university. And I've always thought of law schools as kind of natural collaborators because of our commitment to interdisciplinary approaches to the problems that we're studying. So I think as that kind of work becomes more important to universities, cross-disciplinary work, law schools become important hubs of that. And so I think you'll see law schools moving more towards the center of the work of universities. And we see that also in the commitments that universities are making around the importance of civil disagreement. And that's something that law schools excel at promoting and practicing. And so again, I think that will have the effect of moving law schools more to the center. When I was a law dean, this was becoming more and more of a live issue, and the university would want to launch stuff. They actually got a gift from an alum of the College of Arts and Sciences to promote civil discourse, and they didn't know what to do with it. So they came to me and we started a speaker series out of the law school. It was something that they thought we were good at, and I think they were right. So I think that's part of the future of legal education. And then the last thing I would say is, in the way that Joe talked about at the beginning, with the rise of Westlaw and Lexis, when he was starting the casebook, I do think AI is going to change how we do legal research in ways that are good and bad. But either way, whether for better or for worse, our students are going to need to understand it. They're going to need to understand what it's good at, what it's bad at. I was just having a conversation with my wife about this morning because she's doing some legal research, and she said the AI was really good at explaining a point of doctrine to her that she had struggled to really understand or be able to articulate. And then she said she asked it for quotes, and it made up a bunch of quotes. And so
Right.
the good, the bad, and the ugly, but you have to understand its propensities if you're going to use it effectively. And there, a bunch of lawyers have gotten in trouble in recent years using it irresponsibly. And so we're going to have to, really make sure that our students are prepared to use it in ways that are consistent with its capabilities and its limitations.
Super. Professor Singer, your predictions for the future of legal education in the coming decade?
Well, I agree that AI is going to be something law schools are going to have to deal with in terms of helping students figure out how to use it wisely and helpfully. I do think that, we've seen over the last 30 years a move toward increased clinical education in law schools, and I think that's going to continue. And I think that's a really terrific thing that, it depends on funding for people because clinical education classes are smaller and it just costs more than the bigger first year classes. There will be, I think, increased law school education books. Like, for example, I have a conflict of laws book called Choice of Law, and the subtitle for the second edition is an experiential learning approach. So I have a book where it's not clinical education, but the way I structure the course is to have 11 moot courts with students being both judges and lawyers and getting coached by the professor in terms of how to write short drafts of what opinions would say and doing oral arguments and acting as judges. So I think there's going to be a move toward that type of education in the future. I also, want to say that some of the basic things that law schools have done for 100 years, we will continue to do, and they are needed. I don't think law school education, the way it's been done for the last 100 years or more, is going to become obsolete. And the reason I say that is AI may be good at some things, but it's not good at moral judgment. It's not good at telling you what the right thing to do is. That really has to come from human judgment. That has to come from conversation, has to come from civil discourse, has to come from carefully understanding the arguments on both sides of a hard case and exercising judgment. Legal education is quite helpful in terms of analysis. We break down a problem. We don't say it's a yes/no thing. We realize that the problem involves 24 choices, and to figure out you could yes on this, no on this, yes on this, no on this. That analytical ability is something that AI might be able to help with, but I don't think it will be able to have the same kind of human judgment about what's reasonable to categorize as a separate issue. A lot of people with law degrees become business executives because law school actually helps you analyze a problem into its different parts. But it's also the case, again, that legal education is a lot about moral judgment, about what's the right thing to do, how to think about the effects of laws on human beings and human dignity, fairness and justice. There's not an algorithm for fairness and justice. And I think law schools educating people to be able to make decisions and give wise advice in the face of AI helping them with information. In that sense, I think that part of law school is not going to change and should not change because it's desperately needed.
Very well said. I thank you, gentlemen, for being with me today to talk about Property Law Rules, Policies, and Practices 9th edition and other important topics related to property. If you'd like to listen to additional thought leaders on legal education, you can find additional episodes of Aspen Leading Edge on your favorite podcast channel or on YouTube. Thanks for listening.